rainy night. They actually thought about closing the library early, but because of the program, we are staying open to the full-time 8 o'clock. Because it is an honor to have Mass here. I asked him for a biography to write up when we advertise. I had no idea what a guy we have here.
You're that old?
Let me just read a few things about him. He's been the handgun editor of Guns Magazine and law enforcement officer of American Handgunner since the 1970s, and has published thousands of articles in gun magazines, martial arts publications, and law enforcement journals. He is the author of more than a dozen books on firearms. In fact, I had all his books on display. They're all checked out. Self-defense and related topics, including In the Gravest Extreme, widely considered to be the authoritative text on the topic of the use of lethal force. Mass has received judicial recognition as an expert witness for the courts in weapons and shooting cases since 1979, and has been a fully sworn and empowered part-time police officer for 36 years. He founded the Lethal Force Institute in 1981 and served as its director until 2009, and now trains through his Massad Ayoob group. He has appeared on CLE TV, delivering continuing legal education for attorneys to handle deadly forces cases through the Armed Citizens Legal Defense Network. We are just honored to have him here tonight. I'm so glad so many of you came out for this presentation. Thank you.
Thank you, Ms. Gang, thank you all for coming with a hurricane warning and everything. I was going to be able to say it was a dark and stormy night when I thought the controversy over it really goes back to another dark and stormy night in Florida. It's late February 2012, and the proverbial shot rings out in Sept, Florida. Trayvon Martin, age 17, is dead on the ground. The man who shot him is now undergoing severe scrutiny. The parents of the young man, who knew that he was, shall we say, a troubled youth, but may not have known at that time the depths of that, were understandably grieving. They reached out to Benjamin Crump, the well-known police attorney here in Florida. Mr. Crump reached out in turn to a gentleman named Ryan Jewelison. Keep that name in mind because you'll be hearing more about it. Mr. Jewelison runs a very high-powered public relations firm with a great many connections with the national media based in New York. He takes a picture of Trayvon Martin at age 12, and essentially with his connections at CNN and MSNBC, the meme is born. The innocent child skipping down the street with a box of Skittles is gunned down by the evil white racist for no reason but to satisfy his bloodlust. It becomes an international cause celeb. The world has heard only one side of it. The kid who pulled the trigger is a 27-year-old young man who is completely blindsided by this and has no knowledge of managing the media. By the time he's retained counsel, it's too late. The meme has grown like Thompson and exists to this day. On July 13, 2013, George Zimmerman was acquitted. The general public to this day, a huge percentage, believe that he got away with racially motivated murder. The press had overlooked the fact that George Zimmerman himself was 1/8 black on his mom's side, that he and his wife had spent a great deal of time mentoring underprivileged black kids. They called him the self-appointed watch commander and vigilante. He, in fact, was the duly elected community watch chairman of the community, and was very well respected by his liaison officers with the Sanford Police Department. None of that mattered. Another meme had been born, manipulating the judicial system, if you will, through publicity. 2014. A few more shots ring out, this time in daylight, in a small town in Missouri near St. Louis. A young man who has violently attacked a police officer, attempted to disarm him, has left his DNA on the officer's gun, has sustained a muzzle contact gunshot wound to the arm when the cop literally shot him off the weapon because it was dead or died. He pursues the young man turns on him, much larger than he. The young man is about 6'4", 300 pounds, and has recently been caught on film within the hour, doing a strong arm robbery of a local convenience store. This was unknown to the officer at the time of the conflict. As he lunges for the officer again, reaching for his gun, the officer fires several shots, and when he collapses, stops shooting. The family of the deceased is understandably upset. I am not sure Michael Brown's parents knew of what his proclivities were. They saw him as the fine young man who was bound for college. And I can understand that. Brief digression. How many of us in here can think back to a few things we did when we were teenagers that we would think, ooh, I'd kill to keep my parents from finding out? How many? Where's the young guy? Notice he's already known, not in front of my face. The parents hire an attorney. The attorney reaches out to Benjamin Crump. Benjamin Crump reaches out to Ryan Jewison. Does anyone see a pattern beginning to emerge? And soon we have hands up, don't shoot, poor innocent youth gunned down by bloodthirsty racist police officers. The evidence proves beyond a shadow of a doubt, which is why it never even got past the grand jury that failed to indict the officer. The evidence shows beyond a doubt. The hands were never up. He was never on his knees. The statements that the officer had shot him in the back as he lay prostrate were completely contradicted by the hard, irrefutable fact of it. Ryan Julius, in effect, was born. It began with an armed American citizen here in Florida. We're seeing it now somewhat more with police, but any of you who keep or carry a gun for self-defense is something to bear in the back of your mind that you should be concerned about. Something else was not so much born that night, but it had been smoldering, and the Zimmerman shooting poured gasoline on it. In the year 2005, Florida had been one of several states then that had what was called a retreat requirement for you to use force in self-defense, including deadly force if the other person was trying to kill you. The law was seen to require you to have at least made an attempt to retreat. Well, what the law actually said, and what it always said in every state that had that requirement, was that retreat was only demanded if it could be accomplished in complete safety to yourself and other innocent parties. If you go back in history, that's what it said in the state of Florida, but a whole lot of folks didn't read the fine print. You'll find when folks talk about laws, they don't use the term low information voter phenomenon. Okay, people read a headline of an editorial, and maybe not even the whole editorial, which is generally BS too. And they say, ooh, it says here anybody can kill anybody for anything and get away with it by just pleading self-defense. And that basically was what the poles of the argument were when in 2005 some wise legislators put together a package that said we need judicial reform on this and related matters. The so-called stand your ground laws have since become known was actually a four-part legislative package. There was the element that it was named for. Florida Statute 776.012 rescinded the previous retreat requirement. It said simply, if you're attacked in some place where you have a right to be, you are not committing a crime, you are not the initial aggressor, you don't have to retreat before you use appropriate, reasonable force to defend yourselves and to defend others. Now, I do not see this as having been a great sea change in the rules of engagement, if you will, for the private citizen who has guns. It was simply a clarification. Let me ask you all one question. It's a question I've been asking people since before that legislation. If any of you were in a situation where you felt you could simply walk away and nobody was going to get hurt, would any of you instead pull out a gun and shoot a human being to death? I'm an old man. They tell me I I've got cataracts for me and I've got to hold them blind. Help me and look around, because I'm not seeing any hands. So it's not just me. And that's why it didn't really change the rules of engagement. Also in that legislative package, the wise legislators who brought it forth said, you know what? It's been understood since the Middle Ages that the person's home was his castle. The terminology comes from the English common law, from which our own derives. It said the person's home is their castle, and attacked there by an intruder, they need not retreat. Now, it was the same common law doctrine that said the cottage of the most humble peasant is his castle, and even the king may not enter without invitation or warrant. But we'll save that if we ever do a Fourth Amendment election. Essentially, the right to self-defense was the cornerstone of castle doctrine as it applied to this particular concept. It was simply clarified in 776.013. You could find it in Florida law, but here's the deal. A lot of folks who just look at the law superficially, particularly in the time of the internet, will do a Google search and say, does our state have castle doctrine? Check Florida. Well, there are three places where you look for that sort of thing, and most people don't get past the first. The first place to look, obviously, is what the courts call, what lawyers call colloquially, the black letter law. The black letter law is the statutes and the codes of your state. They say, here is what is forbidden, and here is what the penalty shall be if you're found guilty of breaking this law. But you'll also find these subtleties in the case law. The case law is the decisions by the higher courts, the courts of appeal, that guide the lower courts, the trial courts, and tell them here is exactly how all the subtleties of applying this principle should apply in an actual trial for one of our citizens. The third place to look is your state's recommended jury instructions. And if you had looked under there, and if anybody had looked under there prior to 2005, they would have found, yeah, you're only required to retreat, if you can do so in complete safety. If you're attacked by a stranger in your home, no, you don't have to jump out the window or put your back to the wall before you shoot if the guy comes in swinging a machete. But by putting it in the black letter law, 776013, clarified that and made it a whole lot easier for the public, which is the jury pool, to understand. There were also two elements of court reform, if you will. Both were encompassed under 776.032. These said that, look, first on the criminal side, if the evidence shows to a preponderance of evidence, that is a greater than 50% certainty. Again, brief digression, law professors put numbers on things, judges by and large do not. Different law professors will tell you that a preponderance of evidence means a 51% certainty, a 50.1% certainty. Judges realize that the jurors are not engineers or mathematicians, and they will generally formulate that instruction as simply more likely than not. What 776032 says is you're entitled to a hearing in front of a judge if you have raised a self-defense issue after using force on another. You present your evidence. Essentially, the hearing is a mini bench trial with no jury involved, just the judge. If the judge determines that to a preponderance of evidence standard, you're more likely than not, it was self-defense, the judge has the power to kill the case there. It's done. It's terminated with prejudice. It's a vampire with a stake in its heart and in the casket, and it's not going to rise. The fourth element was also judicial reform, and in that sense it was tort reform, the lawsuit side of it. Absolutely anyone can sue anyone for anything. You've all heard that? It's true. They can at least bring suit for anything. What we had been seeing in the past in Florida and elsewhere was some absolutely outrageous stuff. If you shot Charles Manson while he was chopping up a nun on Ohio Avenue in front of 200 witnesses, it was theoretically possible for the Manson family to file a lawsuit against you for depriving Charlie of his rights to life, liberty, and pursuit of innocent victims. And if that went to trial, which you have to understand, criminal or civil, trials don't come cheap. law says if you're tried and found not guilty, your legal fees should be reimbursed. Good luck with that. I've been doing homicide trials in the state of Florida since 1984. Good luck with that. A good attorney is going to start at about $300 an hour. Mark O'Mara, who led the Zimmerman defense, I'm told, is now getting $1,000 an hour. Now, when you figure how many hundreds and hundreds of hours go into the preparation of a trial, it's not just the week of trial. It's the weeks and weeks that build up to it. Okay, it tends to bankrupt people. It bankrupts families. Okay, the last murder trial I did was in February in Minnesota. He was a retired man at 66. He comes home. He lives alone with his wife, who's his age. They're both retired. They have a closed garage, so he can't tell whether her car is in or not. But it's the time of day she's supposed to be at home. As he pulls up, he sees his front door is hanging off the hinges. It's been kicked down. He looks through an open window, and here is this physically huge man inside that he's never seen before. His only thought is, my God, my wife is in there. He's licensed to carry a gun. He grabs his 9mm pistol out of the glove box. He goes running out of the house. The guy has seen him. When the guy runs to the back door, he's trying to get out, and I'm not going to set off this alarm, but picture, I'm sitting here rattling desperately at the door, and it won't open because that door was stuck. This guy comes in, tells the guy to stop. He has the pistol in his hands like this. The guy looks at him and says, "I'm gonna hurt you." Lunges at him like this. Our guy comes up and fires one shot. He perceives the man to turn away and run. The guy literally dives out a window, runs to his car, gets in the car, runs out of blood and dies. Anybody in here have a problem with that? I don't think a Montana jury would have either. I cannot speculate to the motives of the prosecutor. We're being recorded, and I try to live my life as if I'm being recorded anyway. The prosecutor in 2009, when he was head of his state's Prosecutors Association, had testified in the Montana State Legislature against a bill that would have reinforced Castle Doctrine. Well, the state legislators in Montana politely said, "Thank you for letting us listen. We're passing it anyway." His nose was a little bit out of joint. Was he maybe looking for a case, looking for a sacrifice, looking to make an example? I don't know. You'd have to ask him. We do know after more than 300 days, he decided to indict the man. The charge was what they call in that state deliberate homicide and what would be called here premeditated murder. So he was looking at life without parole on the table, and this is a man of 66. An excellent attorney named Quentin Rhodes won that man's freedom for him. The cost of trial was such, he ended up having to get a reverse mortgage on his home to pay for it. And I know Quentin Rhodes gave him a damn good deal on the legal fees. That was the sort of injustice that the legislative package here in Florida in 2005 was designed to forestall. You don't ruin someone financially by weaving a case out of whole cloth in the name of political correctness, in the name of political agenda, in the name of winning some more votes from whatever group you're playing to that week in the next election for district attorney. What here in the state would be state's attorney. So that was why this legal package was formulated. On the lawsuit side of it, same thing. If the judge in what came to be known as stand your ground trial has determined to a preponderance of evidence that self-defense, the judge has the power to kill the case right there. State vampires are W. Does it exactly work that way all the time? Not necessarily. The whole oversimplification of doing this thing from all the talking heads in the media and then in the political world. On one side it was like, oh my God, stand your ground, Satan has risen in Florida, everyone will kill everyone and get away with it. And on the other side was, well, heck, fire. From what I read in the newspaper, I can shoot anybody on my property now. As you might gather, the truth was very much centered in the middle between those two extreme poles.